distribution, manufacturing. Owners in our state who were legally licensed to have breweries and restaurants up until the law changed last year that told them you can't do this anymore even though you've been doing it for years. This, I think, is fundamentally unfair, and I have yet to hear a very good reason why these businesses should have to adapt, whether that takes them 2 years to do or not. They are being told you cannot do this anymore. I don't believe that when that bill last year, and it was LD 1456, sponsored by our good president here, in fact, I don't believe that when that bill passed, we all knew that we were shutting down operational restaurants or setting a chain of events into motion that was going to result in them shutting down. I don't know if you know this, it's not easy to sell a restaurant or a brewery in this particular environment. So if you're telling folks they have to sell, you're basically telling them they have to close. I want to read an excerpt from the testimony that the Maine Brewers Guild presented to the VLA committee last year related to LD 1456. This testimony is online. You can look at it. 1456 comes from Sarah Bryan, the executive director of the Maine Brewers Guild. She makes a lot of good points about why we should maintain the three-tier system. What she says specifically about the bill that we passed last year is this, quote, "Our due diligence has turned up no records of existing breweries that currently extend outside the proposed location cap of 6. And we have worked consistently with our colleagues in both wine and distilled spirits who are supportive of these changes." So what I am asking you to do, colleagues, is support the restaurant industry, the hospitality industry, which is struggling right now, to support these 3 business owners that have multiple locations in rural Maine that would like to stay open, that would like to stay employing people, because I don't believe it was ever our intention to shut them down. Certainly we didn't have the information that we have now about the impact of that legislation. The reason that I'm involved in this legislation is that 2 of the 3 business owners live in my district, and people that I represent, I do believe will be affected. It's nice to know that they might not be affected for 2 years, but I really would like for them to have certainty in their lives that they can continue doing what they've been doing successfully ongoing. That is all that I'm asking for. I hope that you will consider the position that I'm in, the work that I'm doing to help these constituents, and what it would be like for you if you learned that many people in your community woke up one day and were told, what you're doing, you were good at it, but we're not going to do that anymore here in the state. So please consider whether or not you knew you were putting restaurants out of business, or that will be the ultimate impact, because that is what they are telling me. If you knew that and you were okay with it, please do vote against this motion. But if you didn't know that and it gives you any pause or concern, please let me have a chance to make this right for them. Thank you.
The pending question before the chair recognizes the senator from Androscoggin, Senator Timberlake.
Thank you, Madam Chair. And I guess my reply to the good senator from Hancock would be that I hope everybody here that votes in favor of this amendment keeps in consideration every law that we change that has affected every business in the state of Maine that has had a negative impact. I can think within my own businesses within the last few years, some of the rules and regulations that we've passed within this building that come back to haunt us. So if it's all about the laws that we passed last year, we didn't realize we're going to have the negative impact, you better take a look at what we passed this year that have had a negative impact on businesses in the state of Maine. We're hearing the chamber, we're hearing everybody scream and yell about all the laws that this place puts on businesses. I look back in our family business and just some of the housing and regulation laws that we put in place, some of the changes that we make in container laws, some of the changes
the chair
that we make in spray.
The chair would ask the member to defer and remind the member to try to keep their comments to the received motion and the underlining bill.
The received motion has an amendment on it, right?
Not yet, hasn't been offered. I have shown great latitude.
Then I'll sit down.
The chair recognizes. The chair recognizes. The chair recognizes Senator from Oxford, Senator Bennett.
Madam President, I just called for order.
Much appreciated. The chair recognizes the senator from Penobscot, Senator Baldacci.
Thank you. I want to rise in support of the pending motion. There are two businesses in Bangor that would be closed by this. My argument to all those who feel that they're pro-business is that if you're a business person and you invest significant money in a business that is legal and you follow all the rules and you've done it for a long period of time and you employ many people, and then, and I've been very persuaded by Senator Grochowski's research when the testimony to the committee was that this is not going to affect anybody. Every single business person shouldn't have to have a lobbyist in Augusta to make sure that they're not going to go out of business. But what you're going to be doing, grandfathering should be the default position, and we've done that in other cases. We did that with, I believe, cigarette shops and supermarkets. Grandfathering should be the default position when you're basically telling people you got to shut their business down. The 2-year, 3-year off-ramp, if you're a restaurant owner or a brewery owner, any kind of business person is basically saying this is your time to transition out, because not only is your business worthless now, you have to end it. So I think that I understand the arguments. This is a highly regulated, profitable business. This isn't, and trying to make sure people are treated fairly, I understand that. But when you're already doing business and you've committed the money over time, you've followed the laws, I think that this is an issue of basic fairness. Thank you.
The pending motion. Chair recognizes the senator from Androscoggin.
The approach to rostrum.
So moved. The Senate will be at ease. Leadership is invited, as well as the senator from Hancock, Senator Grochowski. Senate will be in order. The chair would ask the Sergeant at Arms to please escort the senator from Cumberland, Senator Persh, to the rostrum.
What are you doing? You're just talking.
Can I have you read this through here while I run into the back?
Is it The pending question before the Senate is to recede on unfinished 4. Should I recommend something right now? The chair recognizes the senator from Androscoggin, Senator Timberlake.
Question through the chair.
Sure.
My question is, does this take a 2/3 vote or just a majority vote?
Majority vote. The pending question before the Senate is recede. If you are in favor of receding, you will vote yes. If you are opposed, you will vote no. Is the Senate ready for the question? The chamber staff will secure the chamber, and the secretary will open the vote. Oh, I'm sorry. Did I miss somebody? Have all now voted? Secretary will close the vote. The chair will read, the chair will announce the vote. 25 senators having voted in the affirmative and 10 senators having voted in the negative. The motion to recede has prevailed. The chair will ask that the President of the Senate be escorted back to the rostrum.
The chair recognizes the senator from Hancock, Senator Gajowski. The chair would apologize. Her throat started closing.
Madam President, I move the Senate recede, whereby we adopted Committee Amendment A.
Chair recognizes the apologies. The senator from Hancock, Senator Gajowski, moves that recede, whereby we adopted Committee Amendment A. Is this the pleasure of the Senate? Is it now the pleasure, the chair now recognizes the senator from Hancock, Senator Gajowski. The chair will be quite honest, I just had to go take an allergy pill. That's why I'm a little. Chair recognizes the senator from Hancock, Senator Gajowski. Senator from Hancock, Senator Grahowski, moves that we recede whereby we adopted Committee Amendment A. Is this the pleasure of the Senate? It's a vote. The chair now recognizes the senator from Hancock, Senator Grahowski.
Thank you, Madam President and colleagues. I present Senate Amendment A with a filing number of S633 to Committee Amendment A and move its adoption.
The senator from Hancock, Senator Grahowski, presents Senate Amendment A with a filing number of S63 to Committee Amendment A, moves its adoption. The secretary will read Senate Amendment A.
Senate Amendment A to Committee
The
Amendment A.
chair understands the senator from Hancock, Senator Grahowski, moves that further reading of the Senate Amendment be dispensed with. Is this the pleasure of the Senate? The chair recognizes the senator from Kennebec, Senator Hickman.
Thank you, Madam President. I request that the vote be taken by the yeas and nays.
The senator from Kennebec, Senator Hickman, requests that the vote be taken by the yeas and the nays. In order for a roll call to be ordered, it must have the express desire of 1/5 of the members present voting. All those in favor of roll call, please raise your hands. Obviously, more than 1/5 of the members present voting are in favor of a roll call. A roll call has been ordered. The chair now recognizes the senator from Hancock, Senator Grahowski.
Thank you very much. Colleagues, just because this has been a little bit of a confusing procedure, I just want to let folks know that what I have proposed is a Senate amendment which would do what was discussed in the previous debate to some extent. It specifically grandfathers in the licenses of the folks that were affected by the law change last year. It is very, very specific. The licenses may not be sold, transferred, or otherwise conveyed. We do know the full universe of people and establishments that this affects, and it is not meant to be an expansive clause. It is online, but that is the purpose of the amendment, and I'm happy to take any questions. Thank you.
The chair recognizes the senator from Kennebec, Senator Hickman.
Thank you, Madam President. I could read a series of emails here, but I'm only going to read one. I oppose this motion. So this email comes from, well, I'll just read the email. Hey, Craig, I just wanted to drop you a quick note. I wanted to let you know that we are opposed to the grandfathering clause for LD 2155. I feel the clause sends a tough message to those of us who have grown our businesses within the confines of a very clearly written law to allow folks who ignored it to have an unfair advantage. As a business owner who has had to sell a restaurant to stay in compliance, I only ask that the new, more generous, less restrictive law be enforced more fairly than the law it replaced. I appreciate any assistance and happy to talk further. Tobias Parkhurst, Cushnock Brewing Company.
Chair recognizes the senator from Kennebec, Senator Searway.
Thank you, Madam President. I just had a question, if possible, to answer.
The senator from Kennebec, Senator Searway, would like to pose a question. The member may proceed.
So how long is this grandfathering going to be? Is it just for a year to get it straightened out, or 2 years, or is this going to be just ongoing? I think that that's an important piece that I would like to know.
The senator from Kennebec, Senator Searway, has posed a question to any member of the Senate who may wish to respond. The chair recognizes the senator from Hancock, Senator Grahowski.
Thank you very much, Madam President. Thank you for the question. So the grandfathering says to the businesses that are currently operational, you may continue as you have been. I can't promise how long that will be because another legislature could come in and change things again, but for the time being, it would be ongoing until otherwise changed. I would like to respond also to a previous comment, if that's all right. Thank you. I can appreciate what the senator from Kennebec shared with us. However, I really am concerned about what that was implying, which is that these business owners were not operating legally. I want to be very, very clear. They were operating legally. They are licensed by Bablo. They are right now in an awkward period where they are not able to get their licenses renewed because of the law change, but nobody was breaking any laws. People might not have liked other people's business practices, but nothing illegal was happening here. I just want to clear that up because I think that was a little confusing. Thank you.
Chair recognizes the senator from Kennebec, Senator Hickman.
Thank you, Madam President. The amendment that this amendment replaces, and this is a different answer to the good senator from Kennebec, my colleague from the northern Kennebec County. The reason why I'm kind of stuck where I am on the committee amendment is because it grandfathers these businesses for 3 years, which allows time for them to figure out what they want to do, and it allows time for the legislature to review the underlying policy if it decides that there's something that we could do that's even more fair to everyone in the playing field without giving 3 businesses an unfair advantage for some indefinite period of time that we do not know about. Thank you, Madam President.
Chair recognizes Senator from Androscoggin, Senator Timberlake.
All right, we'll see if we can get on the right page this time. And I thank you, Madam President, ladies and gentlemen of the Senate. I think what I'm hearing is that we passed a law last year that became law, that now these folks are not in compliance with. Well, we pass thousands of laws every year. And these people now have to come in compliance with the laws that we passed. And because it's an inconvenience to them, we think we should grandfather these 3 businesses. I don't see that as the way that this operates. Over the thousands of laws that we've passed in the last year, hundreds of them have been anti-business. You know, we look at some of the laws that we've passed that have to do with our electrical rates, that have to do with all the other things that we do. We pass laws every day in this place that I feel are anti-business. And businesses either have to adjust to them or go out of business. This is a law that we passed last year. I thought the VLA committee went above and beyond what most legislators would do. We gave them basically a 3-year off-ramp to come into compliance. We pass laws every day, the Paid Family Medical Leave Act that's coming into play in May, that the businesses in the state of Maine have to come into compliance with. It's going to drive some of those businesses out of business. But yet they're going to have to come into compliance. Are we going to come in because a business comes in and says, hey, paid family medical leave is driving me out of business, would you please grandfather me? You have to look at that as doing the exact same thing as what this law is doing. We have created laws that are inconvenient. And if you want to change this law to do what the good senator wants to do, then we need to change the 3-tier system and change the law so everybody is treated exactly the same. And if I've been frustrated and I sound frustrated, it's because I am. I sit in here and I watch my friends go out of business. You've heard me say it before, 20% of the farmers go out of business every 2 years. And a lot of it's because of the laws that we impose on them. I guess what I should do is every one of those that want to go out of business, I should get them to come in and have each and every one of you put a bill on that exempts them from those laws, that exempts them from having to meet them laws that grandfathers them. Because that's what you're asking with this bill. I'm sorry if we passed a law last year that's inconvenient to these companies. But we went through it and we studied it and we put out a law and we passed a bill. And I thought we did a good job as a VLA committee of giving them an off-ramp and figuring out a way of how to get there. I could tell you that if I was in their predicament, 3 or 4 ways they could solve the problem and not have to sell their business and not have to do anything else. But I'm not a lawyer. I don't get paid my seatmates' wages. So I ain't going to do that. Or a business advisor. But I can tell you that it can be done. So I'll be opposing this motion because it's the right thing to do to create that level playing field. So I hope you join me in opposing the pending motion.
Chair recognizes the senator from Lincoln, Senator Rennie.
Thank you, Madam President. I don't think I have the same dog in this fight as some of my colleagues here. But I do feel the need to rise just... there's a few things that seem off, and maybe I'm trying to figure out a little bit of this in my head. So it sounds like the committee amendment would in fact require these business owners to sell their, at least part or in whole, I'm not sure how much, ownership stake in these restaurants. Whether that will lead to them closing or maybe they find somebody to buy, I don't know. But I do think that is different than some of the other, I don't know, just because it came up. We have passed a lot of things in this legislature, and some of them are very inconvenient for businesses, and I think I can agree with that. You know, there's more regulation, or there's different payment systems required, and that can be complex. But I don't think it would be fair to equate that to a bill that would require people to sell at least in part or not own anymore their established businesses. I think those are different arguments. So maybe I'm asking this. If coming into a compliance with something, I think is different than being told you have to get rid of a piece of your business. So may I ask a question through the chair? Okay. Is it that the committee amendment, the original committee amendment, would in fact, like, is compliance with that in fact requiring the sale of part or total of these people's businesses? Thank you.
Chair recognizes any member of the Senate who may wish to respond. The chair recognizes the senator from Hancock, Senator Grahowski.
Thank you for the opportunity to address that question. You know, I can only share what has been shared with me by 2 of the 3 business owners, which is it is not viable to be told you have 2 years from now to figure out how to get rid of this business, sell it, close it, you decide. That is the choice that they have told me that they see in front of them if this passes. So I don't know if that answers the question, but there isn't like a just gradual come into compliance. It's over for them at that location unless we pass this amendment.
Chair recognizes the senator from Kennebec, Senator Hickman.
I think it's fair to say, Madam President, that the email that I read into the record a few minutes ago says that in order to come in compliance with a new law, you may have to sell a business. And because we passed the law as emergency legislation last year, it's already been in effect for a year. And so the fact that these 3 businesses have not yet been shut down by Bablo means that Bablo is being generous to these businesses where other businesses have already decided to comply with the new law and have sold their restaurants. That's the point that the gentleman made in the email to me. So people can vote how they vote, but imagine having already done this thing to come in compliance with the law we passed a year ago, and now finding out if they had just waited, they might have an opportunity to be grandfathered forever. That's not fair. Thank you.
The pending question before the Senate is adoption of Senate Amendment S633 to Committee Amendment A. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber and the Secretary will open the vote. Have all now voted? The Secretary will close the vote. The chair will announce the total. 19 senators having voted in the affirmative and 16 senators having voted in the negative. The motion to adopt Senate Amendment S633 to Committee Amendment A prevails. So now the pleasure of the Senate to now adopt Committee Amendment A as amended by Senate Amendment A thereto. It's a vote. This bill, having had its two several readings under suspension of the rules, is it now the pleasure of the Senate that this be passed to be engrossed as amended in non-concurrence and sent down for concurrence? It's a vote. Is there any objection to sending this matter forthwith? Hearing none, so ordered. The chair would lay before the Senate, going back to the beginning of our printed calendar, Item 1-3, Item 1-3. Which was tabled earlier pending consideration. The chair now recognizes the senator from Cumberland, Senator Peirce.
Thank you, Madam President. I move the Senate insist.
The senator from Cumberland, Senator Peirce, moves that the Senate insist. Is this the pleasure of the Senate? Let's vote. Chair now lays before the Senate item 5-2, item 5-2.
Item 5-2 is a divided report on your printed calendar.
The chair understands the senator from Knox, Senator Beebe Center, moves the reading of item 5-2 be dispensed with. The chair now recognizes the senator from Knox, Senator Beebe Center.
I move that the Senate accept the majority ought to pass as amended by Committee Amendment A report in concurrence.
The chair is in error. This had been moved previously when the chair was not at the rostrum. There is already a motion that has been moved and a roll call has already been ordered. The chair recognizes the senator. The chair recognizes the senator from Kennebec, Senator Searway.
Thank you, Madam President. I just remind people that this is sealing records, like I say. There's like 3 of them in a row that in this book that we're looking at sealing records. That this is just lowering our standards to the point where I don't see where we're taking care of our victims in society at all. I think that, you know, the Class D crime can be an assault. It can be operating after suspension, which I had one person drive right off the road, fell asleep at the wheel. He told me he'd been driving for 15 years operating after suspension. So it doesn't stop them from doing crimes. So when you go and seal the records.
The member will defer. The chair recognizes the senator from Sagadaw, Senator Tepler, inquires why the member rises.
Point of order, my understanding is that this bill refers specifically to convictions for conduct that are no longer a crime in the state, and I believe the good member is discussing crimes that are still crimes in the state.
The chair would remind the member that the bill title does contain the word sealing, and that would remind all members to keep their comments to the bill at hand. The chair recognizes the senator from Kennebec, Senator Searway, and may proceed.
Well, as far as crimes, when you've lowered the crimes from Class D crimes down to civil offenses, is no longer a crime. So what they're doing is taking crimes that really are crimes, which we've lowered down to civil, and now we're going to seal those records. That's like illegal attachment of plates went to a civil violation, which was a Class D crime. This is what I'm talking about. We are lowering our standards to the point where it's not even fair to the victims out there that may have had a vehicle stolen. I'm just saying that this is just, we are weakening our laws to the point where there's no accountability. We're making it a dangerous state. It used to be the #1 safest state in the country. We're making it the worst safest state in the country. Thank you, Madam President.
Chair recognizes the senator from Cumberland, Senator Nangle.
I believe this is sealing, I mean, what I'm reading is it's sealing records to conduct that's no longer a crime in the state. It's not like we're pardoning a bunch of rioters that attacked police officers and had their records sealed. So
The pending question before the Senate is acceptance. The majority ought to pass as amended report. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? The Sergeant at Arms will secure the chamber. Secretary will open the vote. All now voted. Secretary will close the vote. The chair will announce the total. 21 senators having voted in the affirmative and 14 senators having voted in the negative. The majority ought to pass as amended. The report
Be it enacted by the people, say may as follows. Committee amendment.
Chair stands the senator from Oxford, Senator Bennett, moves the reading amendment A be dispensed with. From the top. The chair understands that the senator from Waldo, Senator Curry, moves the reading be dispensed with. The secretary will read Committee Amendment A.
Committee
Again.
amendment A to House Paper
The chair
1278.
understands the senator from Kennebec, Senator Sirway, moves the reading of Committee Amendment A be dispensed with. It's now the pleasure of the Senate to adopt Senate Committee Amendment A. It's a vote. It's now the pleasure of the Senate that the rules be suspended to give this bill its second reading at this time by title only. It's a vote.
An act to allow the sealing of criminal history record information related to convictions for conduct that is no longer a crime in the state.
Is it the pleasure of the Senate that this bill be passed and engrossed as amended in concurrence? It's a vote. The chair now lays before the Senate item 5-3, and we'll check if there's been previous action. Free and clear. With that, the chair understands the senator from Knox, Senator Beebe Center, moves the reading of item 5-3 be dispensed with. The chair now recognizes the senator from Knox, Senator Beebe Center.
Thank you, Madam President. I move that the Senate accept the majority ought to pass as amended by Committee Amendment A report in concurrence.
The senator from Knox, Senator Beebe Center, moves the majority ought to pass as amended by Committee Amendment A report be accepted in concurrence. The chair now recognizes the senator from Aroostook, Senator Stewart.
President, I request a roll call.
Senator from Aroostook, Senator Stewart, has requested a roll call. In order for the chair to order a roll call, must have the express desire of 1/5 of the members present and voting. All those in favor of a roll call, please raise your hands. Obviously, more than 1/5 of the members present and voting are in favor of a roll call. A roll call has been ordered. The chair now recognizes the senator from Cumberland, senator from Kennebec, Senator Sirway.
Thank you, Madam President. This is another one that's trying to seal records, but I'm just asking a question, if possible, to the body.
The member may proceed.
On a plea agreement, if this was a Class C crime of possibly lowering and having a plea agreement to an assault compared to a sexual assault, would this charge be dismissed?
Senator from Kennebec, Senator Sirway, has posed a question to any member of the Senate who may wish to respond. The chair recognizes Senator from Cumberland, Senator Carney.
This is not a piece of legislation about dismissal of crimes.
The pending question before the Senate is acceptance of the majority ought to pass as amended report. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The secretary will open the vote. Have all now voted? The Secretary will close the vote. The Chair will announce the total. 21 senators having voted in the affirmative and 14 senators having voted in the negative. The majority report prevails. First reading the printed bill.
Be it enacted by
Chair
the
to
people
stand for
sitting as
Waldo, Senator
follows.
Curry moves the reading be dispensed with. The Secretary will read Committee Amendment A.
Committee Amendment
Chair
A
to
to
stand
House
Senator from
Bill
Kennebec,
79.
Senator Searway moves the reading of Committee Amendment A be dispensed with. Is it now the pleasure of the Senate to adopt Committee Amendment A? It's a vote. It's now the pleasure of the Senate that the rules be suspended to give this bill its second reading at this time by title only. It's a vote.
An act to clarify the Criminal History Record Information Act with respect to criminal charges dismissed as a result of a plea agreement.
Is it the pleasure of the Senate that this bill be passed being engrossed as amended in concurrence? It's a vote. Is there any objection to all matters thus acted upon being sent forthwith? Hearing none, so ordered. The Chair lays before the Senate item 5-4. Item 5-4. Their roll call has been ordered. The pending question before the Senate is acceptance of the majority ought to pass as amended report. The Chair recognizes the Senator from Penobscot, Senator Baldacci.
I would ask kind of a parliamentary procedure, but I would ask that this matter be recommitted to committee. So I would make that motion now.
The Senator from Penobscot, Senator Baldacci, has moved that this item be recommitted to committee. Chair recognizes the Senator from Penobscot, Senator Guerin.
I'd like to request a roll call and ask to speak to the motion.
Senator from Penobscot, Senator Guerin, has requested a roll call. In order for the Chair to order a roll call, it must have the express desire of 1/5 of the members present voting. All those in favor of roll call, please raise your hands. Obviously, more than 1/5 of the members present voting are in favor of a roll call. A roll call is in order. The Chair now recognizes the Senator from Penobscot, Senator Guerin.
Thank you, Madam President. I rise tonight in passionate opposition to the motion to recommit 2054 to the IF&W Committee. Let me explain why. The majority report voted 12-1 on this bill out of committee. It accomplishes what the committee voted on and only needs to have a minor typo fixed by an amendment already to be applied in the House. This bill is supported by the Department, the Maine Professional Guides Association, the Maine Sporting Camps Association, and dozens of guides who have traveled to our committee from as far away as Allagash multiple times this session to participate in the hearing, the work sessions, which were multiple, and stakeholder discussions at the request of the committee chair. It is the product of years of discussion among stakeholders. Most importantly, the agency that we charge as stewards to this tremendous resource. The legislation has been covered widely online. We've heard from our constituents. It's been a topic on morning radio and covered by both the Portland Press Herald and the Bangor Daily News. This bill is aimed at making some modest reforms to our hunting outfitter moose permit program, often referred to as the Lodge Tag program. The work that our committee accomplished seeks to create a level of fairness, transparency, and economic opportunity that was originally intended, but over time has been distorted by the exploitation of weak definitions and loopholes. As the Department of Inland Fisheries has noted in a recent memo to us, the recommendations, quote, the recommendations that are included in the amended language are grounded in the principle that moose are a public trust resource managed by the Maine Department of Inland Fisheries and Wildlife for the benefit of all citizens, not a commodity to be bought, sold, or concentrated among those with greater financial means or exclusive connections. As the department puts it, quote, collectively these recommendations maintain fairness, prevent commercialization of access, preserve broad economic benefit, and uphold Maine's long-standing tradition of equitable access to a public trust wildlife resource. Please join me in voting down this motion so we can move on to instead consider and debate the merits and good work of the months of work of the committee and the stakeholders. Thank you, Madam President.
The Chair recognizes another Senator from Penobscot, Senator Baldacci.
Thank you, Madam President. I would just indicate to the chamber that the reason I'm asking that this be recommitted is that this, I understand it's being described as a typo, but it's the history of this bill is very difficult to describe, that it started as a simple bill to clarify things, and it kept morphing into more things. The department regularly changed this. There were changes at the language review. This change would change the percent. The quote-unquote typo is in my opinion, extremely material in that it would change the percentage of permits. Okay? It's not a typo. The department has had this bill in its possession for a while, and they came up with this. All of a sudden they scratched their head and figured out that was wrong or whatever, but it needs to be recommitted, because my concern and why the only reason I voted in the majority was to allow myself to try to reconsider the bill in committee, which failed, because I was hoping that we could reconsider and try to address some of these issues. It is a large market. It's a business market. It's a financial thing. Nobody disputes that. And I don't dispute the goals of the department, but I think that the manner in which they've presented this and kept changing the language, and at this 11th hour want to do it again, causes me concern, as it has from the beginning, that this hasn't been completely thought through, that this is being rammed down people's throats, and I think it's important that we go back to the committee, at least have one more discussion, and clarify all these different issues. Thank you.
The pending question before the Senate is whether we shall recommit this matter to the Committee on Inland Fisheries and Wildlife. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The Secretary will open the vote. Have all now voted? Have all now voted, the Secretary will close the vote. The Chair will announce the total. 19 senators having voted in the affirmative and 16 senators having voted in the negative. The move to recommit passes. The Chair recognizes Senator from Cumberland, Senator Peirce. Leadership. Yes. The Chair now lays before the Senate item 5. Nope, we're moving the supplements, folks. So, to do a recap from the top, we're going to do supplement number 2, 5-1. We're going to do supplement number 5, Supplement number, I'm 5-1. We're going to do supplement number 6, supplement number 7, 8, and 9. So with that, the chair would call members' attention to supplement number 2. Supplement number 2.
On supplement number 2, item 5-1
Chair understands
is a
Senator from Waldo.
divided
Senator
report.
Curry moves the
Committee
reading of
on
item
Housing.
5-1 be dispensed with. The chair now recognizes the Senator from Waldo. Senator Curry.
Madam President, I move that the Senate accept the majority ought to pass as amended by committee amendment A report.
Senator from Waldo, Senator Curry has moved the majority ought to pass as amended by committee amendment A report. The chair recognizes Senator from Aroostook, Senator Stewart.
President, I request a roll call.
Senator from Aroostook, Senator Stewart has requested a roll call. In order for the chair to order a roll call, it must have the express desire of 1/5 of members present and voting. All those in favor of roll call, please raise your hands. Obviously, more than 1/5 of members present and voting are in favor of a roll call. A roll call has been ordered. The pending question before the Senate is acceptance of the majority ought to pass amended report. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The Secretary will open the vote. Chair would note the senator from Sagadaw, Senator Tepler, be excused from roll call votes. Have all now voted. The secretary will close the vote. The chair will announce the total. 20 senators having voted in the affirmative and 14 senators having voted in the negative. The majority ought to pass as amended report prevails. First reading the printed bill.
Be enacted by the people.
Chair understands Senator from Oxford, Senator Bennett moves the reading to be dispensed with. The Secretary will read Committee Amendment A.
Committee Amendment A.
Chair understands Senator from York, Senator Bailey moves the reading of Committee Amendment A be dispensed with. Is it now the pleasure of the Senate to adopt Committee Amendment A? It's a vote. Now the pleasure of the Senate that the rules be suspended to give this bill its second reading at this time by title only. It's a vote.
An act to support owners of manufactured housing, mobile homes, and tiny homes.
Is it the pleasure of the Senate that this bill be passed and engrossed as amended in concurrence? It's a vote. The chair draw your attention to supplement number 5. Supplement number 5.
On supplement number 5, item 1-1 is a
Chair recognizes Senator from
non-concurrent matter.
Cumberland, Senator Peirce.
I move the Senate recede and concur and further ask for a roll call.
The senator from Cumberland, Senator Peirce, moves that the Senate recede and concur and further ask for a roll call. In order for the chair to order a roll call, must have the express desire of 1/5 of members present and voting. All those in favor of roll call, please raise your hands. Obviously, more than 1/5 of members present and voting are in favor of roll call. A roll call has been ordered. The pending question, the chair recognizes the senator from Penobscot, Senator Guerin. The pending motion before the Senate is whether we shall recede and concur. The chair recognizes the senator from Washington, Senator Moore.
I just had a question. I thought she insisted instead of recede and concur. Okay.
She moved to recede and concur. I'm looking for.
Okay, I'm sorry. I misheard.
No worries. It is 7:24. The pending question before the Senate is, excuse me, recede and concur. If you're in favor of receding and concurring, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The Secretary will open the vote. Have all now voted? All now voted. The Secretary will close the vote. The chair will announce the total. 12 senators having voted in the affirmative and 23 senators having voted in the negative. The motion to recede and concur fails. Chair recognizes the senator from Cumberland, Senator Peirce.
Madam President, I move the Senate insist.
The senator from Cumberland, Senator Peirce, moves that the Senate insist. Is this the pleasure of the Senate? Let's vote. The chair lays before the Senate supplement number 6. Supplement number 6.
On supplement number 6, item 1-1 is a non-concurrent matter that
Chair
comes from the
recognizes
House.
the senator from Cumberland, Senator Peirce.
Thank you, Madam President. I move the Senate insist.
Senator from Cumberland, Senator Peirce, moves that the Senate insist. Is this the pleasure of the Senate? Let's vote. Chair now lays before the Senate supplement number 7. Supplement number 7.
On supplement number 7, the Committee on Engrossed Bills report is truly and strictly engrossed the following emergency measure. Item 7-1, an act increasing the debt limit of the West Paris Water District.
This bill, having had its 2 several readings in the House, its 2 several readings in the Senate, and been passed, be engrossed, and reported by the Committee on Engrossed Bills is truly and strictly engrossed, and been passed, be enacted in the House, and signed by the Speaker. It is the pleasure of the Senate that this bill be passed to be enacted. This being an emergency measure under the Constitution, will require for its enactment the affirmative vote of 2/3 of the entire elected membership of the Senate. Members will please indicate electronically how they wish to be recorded. If you're in favor of enactment, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The Secretary will open the vote. Chair would note that the senator from Oxford, Senator Bennett, be excused from roll call votes. Oh. All now voted. The Secretary will close the vote. The chair will announce the total. 34 senators having voted in the affirmative and 0 in the negative. And with 34 being more than 2/3 of the entire elected Senate, this bill is passed to be enacted. This bill, even passed to be enacted, will be signed by the President and presented by the Secretary to the Governor for approval.
Committee on Engrossed Bills report is truly and strictly engrossed. Following emergency resolve, item 7-2, resolve regarding the process of filling vacancies in certain group homes for individuals with intellectual disabilities or autism spectrum disorder.
Chair recognizes the Senator from Androscoggin, Senator Rotundo.
President, I move that this item be placed on the special appropriations table.
The Senator from Androscoggin, Senator Rotundo, moves that this item be placed on the special appropriations table. Is this the pleasure of the Senate? It's a vote.
Committee on Engrossed Bills report is truly and strictly engrossed. The following acts. Item 7-3, an act to regulate the use of artificial intelligence in providing certain mental health services. Item 7-4, an act to implement certain recommendations related to the regulatory review and approval of certain healthcare transactions involving private equity companies, hedge funds, or management services organizations from the Commission to evaluate the scope of regulatory review and oversight over healthcare transactions that impact the delivery of healthcare services in the state. Item 7-5, an act to offset federal cuts to health insurance for certain Maine families and seniors.
The chair recognizes the Senator from Androscoggin, Senator Rotundo.
Thank you, Madam President. I request that we set aside item 7-5.
Senator from Androscoggin, Senator Rotundo, has moved that we set aside 7-5. It will be set aside. In regards to 7-3 and 7-4, these bills, having had their 2 several readings in the House, their 2 several readings in the Senate, have been passed to be engrossed and reported by the Committee on Engrossed Bills as truly and strictly engrossed, have been passed to be enacted in the House and signed by the Speaker. It is the pleasure of the Senate that these bills be passed to be enacted. These bills are passed to be enacted and be signed by the President and presented by the Secretary to the Governor for approval. Chair now recognizes the Senator from Androscoggin, Senator Rotundo, in regards to 7-5.
Madam President, I move that this item be placed on the special appropriations table.
The senator from Androscoggin, Senator Rotundo, moves that this item be placed on the special appropriations table. Is this the pleasure of the Senate? It's a vote. The chair now calls your attention to supplement number 8. Supplement number 8.
On supplement number 8,
Chair
item
understands Senator from
5-1,
Cumberland, Senator
divide
Carney moves the
report.
reading of item 5-1 be dispensed with. The chair recognizes Senator from Cumberland, Senator Carney.
Madam President, I move that the Senate accept the majority ought to pass as amended by Committee Amendment A report in concurrence.
Senator from Cumberland, Senator Carney moves the majority ought to pass as amended by Committee Amendment A report be accepted in concurrence. Chair recognizes Senator from Aroostook, Senator Stewart.
Madam President, I request a roll call.
The senator from Aroostook, Senator Stewart, has requested a roll call. In order for the chair to order a roll call, must have the express desire of 1/5 of members present and voting. All those in favor of roll call, please raise your hand. Obviously, more than 1/5 of members present and voting are in favor of roll call. A roll call is in order. The pending question before the Senate is acceptance of the majority ought to pass as amended report. The chair recognizes the senator from Cumberland, Senator Talbot Ross.
Thank you, Madam President. I rise today in support of LD 2106, an act to prohibit the disclosure of non-public records without proper judicial review, renamed in the majority report to be an act to limit consent for entry into non-public areas of and to limit access to protected records maintained by certain public entities. This bill will help protect certain sensitive places, such as our public schools and libraries, so they remain safe and accessible to everyone in our communities. Simply put, LD 2106 limits how and when public schools, state health facilities, and certain libraries can let federal immigration enforcement enter non-public areas or see private records. It requires the Office of the Attorney General to create model policies and guidance that limit voluntary cooperation with immigration enforcement within the scope of state and federal law. Under this bill, the staff at covered public facilities would not be permitted to voluntarily allow immigration enforcement officials into non-public areas for immigration enforcement, or voluntarily provide access to private education records, healthcare information, and library patron records consistent with state and federal law. By ensuring that access to non-public spaces and sensitive information occurs only through required legal processes, we protect the rights of all Mainers, not just immigrants, by safeguarding access to education, healthcare, and public libraries. These are common sense measures that provide clarity for institutions and reassurance for our families. This issue is an abstract. In September of 2025, a 42-year-old father was detained by ICE officers outside of the Gerald E. Talbot Community School in Portland, part of the city I proudly represent. While dropping his child off at school, the father was detained by officers wearing vests that said, "Police," no particular affiliation, and they refused to identify themselves to the school staff. While this bill would not change what happens on a public sidewalk, it does address the fear and disruption these actions cause by ensuring our schools themselves are not drawn into immigration enforcement unless legally required. Immigration enforcement in areas like these has real consequences on our students and our families. You don't have to take it just from me. Data from the Portland schools showed absence rates as high as 32% in one elementary school during Operation Catch of the Day, which took place from January 21st to January 29th throughout our state. However, district-wide in Portland, the absence rate increased by 10%. Unfortunately, this was not an isolated incident, particularly during that January surge in immigration enforcement. Our students should not be afraid to go to school, and their families should be able to drop them off safely. Education is fundamental to a child's development and crucial to securing a strong future for the state of Maine. Just one other data point, according to the Deportation Data Project, of the approximately 200 detained during Operation Catch of the Day, only 12 had criminal records. That's 200 were detained, 12 had criminal records. This is not focused on the worst of the worst. Colleagues, I urge you to support the majority report and pass this common safe measure to protect all Mainers. I thank you, Madam President.
The chair recognizes the senator from Cumberland, Senator Duson.
Thank you, Madam President. Women and men of the Senate, it's my pleasure to follow comments of my colleague from Cumberland, Senator Talbot Ross. I rise in support of the pending motion. This bill before us seeks to protect the places and spaces where Mainers gather to learn, heal in times of illness and injury, and be in community with one another. LD 2106 will help protect the safety and integrity of certain sensitive places for people of all backgrounds and ensure everyone can feel safe. As the good senator from Cumberland, Senator Carney, mentioned, this bill includes necessary exemptions for legitimate law enforcement activity conducted under a valid court order or as required by state or federal law. For context, the policies suggested in the majority report are not novel. In fact, at the federal level, internal policies similar to those in the majority report were established under the Clinton administration, enhanced under the Obama administration, and continued through the first administration of the current president, only to be recently rescinded by the current administration. As a retired attorney, I understand the weight and power of the rule of law. The recent spike in federal immigration enforcement here in Maine shows why clearer guardrails are necessary at the state level. I thank the good sponsor for introducing this important bill and move the conversation around this issue forward. Today, this body has the opportunity to make a real difference in the lives of not only our immigrant neighbors, but all Mainers. Residents in my district and many others feel the weight of the non-targeted federal immigration activity. This bill is a step in the right direction to ease fear and restore a measured approach, one that keeps all residents safe. Please join me in supporting LD 2106. Thank you, Madam President.
The pending question before the Senate is acceptance of the majority. The chair recognizes the senator from Penobscot, Senator Herring. And by Herring, I mean Hagan. Apologies.
Same thing. Known her for a long time. Think just like her.
Oh, man. Please proceed.
Thank you, Madam President. I stand in strong opposition to the proposed bill that seeks to restrict public institutions, schools, libraries, and health care facilities from cooperating with federal immigration enforcement officers. While the stated intent of this legislation is to protect residents regardless of immigration status, the reality is that it presents serious legal, operational, and constitutional challenges that cannot be ignored. First and foremost, this bill risks violating the Supremacy Clause of the United States Constitution, which clearly states that federal law is the supreme law of the land. Immigration enforcement is a core federal responsibility. By limiting voluntary cooperation with federal immigration officers, this bill directly interferes with federal authority. We need only look at to Arizona versus the United States in 2012. In that landmark decision, the U.S. Supreme Court struck down major provisions of Arizona's immigration law, stating that the federal government has broad, undoubted power over immigration and that state laws that interfere with federal enforcement priorities are preempted. The court emphasized that even well-intentioned state laws cannot obstruct or conflict with federal objectives. The Maine legislation mirrors the Arizona law in its intent. It effectively limits federal access to information and facilities, creating a legal obstacle to enforcement. Like Arizona, our state risks being sued and enjoined for violating federal supremacy. Beyond constitutional violations, this bill imposes massive operational burdens on our public institutions. Schools, libraries, healthcare facilities will be forced into quasi-legal roles, interpreting when cooperation is allowed and when it is prohibited. Schools, healthcare providers, and libraries are not legal adjudicators, yet this bill effectively deputizes them and makes to make complex determinations about when cooperation is permissible, when it is prohibited, and how to interpret overlapping federal and state requirements. To expect educators, nurses, administrators, and librarians to navigate these waters in real time is not only unrealistic, it is irresponsible. Consider the operational burden this creates. Institutions will be required to develop, interpret, and continuously update internal policies based on evolving legal guidance, train staff to distinguish between voluntary and mandatory compliance under varying circumstances, manage interactions with law enforcement in ways that may be legally ambiguous and potentially confrontational. This is not streamlining governance, it is complicating it. While the bill proponents argue it will protect immigrant communities, it is unlikely to achievely resist federal enforcement, but not practically stop it. Meanwhile, institutions bear the cost and risks. Staff training, policy updates, legal fees, and administrative burdens. This is a classic case of policy overreach with minimal benefit and significant harm. Arizona demonstrates the inevitable legal challenges that arise when states try to regulate in federal immigration. This bill would likely face immediate legal scrutiny and could be invalidated in court, wasting taxpayer money and destabilizing the very institutions it seeks to protect. We should not invite costly litigation by passing a law that explicitly conflicts with federal priorities. This bill violates the Supremacy Clause by interfering with federal immigration authorities. It imposes unfunded mandates. It compromises public safety. It is symbolic rather than practical, with high risk and low benefit. It invites lengthy, expensive litigation, as history shows in Arizona and elsewhere. Please vote against this thing. Thank you.
Chair recognizes the senator from Cumberland, Senator Carney.
Thank you, Madam President, colleagues of the Senate. I just want to provide some clarity in light of the remarks from my good colleague from Penobscot. The constitutional challenges at play here are actually the unconstitutional searches and detentions rather than by federal agents in the derisively labeled Operation Catch of the Day. It is, the bill isn't creating constitutional challenges, it's actually striving to clarify them, and it does so by basing its framework on the well-settled immigration, the well-settled limits on immigration enforcement that have been in place for decades. And I'll just read a little bit from the bill to assure members of this chamber that there is nothing about this legislation that conflicts with federal law. So, for example, the requirements require those to act to the fullest extent possible and consistent with state and federal law. And that phrasing runs throughout the legislation. It's not about challenging supremacy, it's about clearly identifying what constitutional rights everyone in this country is entitled to have protected. I also just wanted to reflect on the assertion that this legislation would cause confusion. It's actually intended to do the opposite. It provides clear guidance from the Office of the Attorney General to certain specific public entities like public hospitals and educational establishments on what can and can't be demanded and what information remains confidential and private and can only be surrendered in the presence of or in response to a federal warrant that's issued by a judge. There's also a really nice aspect of this legislation that allows these policies that are developed to advise public entities to also be used as model guidance for private entities who want to make sure that their employees do not run afoul of confidentiality laws in the face of demands by federal agents. I strongly support this legislation and urge my colleagues to vote in favor of the pending motion.
The pending question before the Senate is acceptance of the majority ought to pass as amended report. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The Secretary will open the vote. Chair would note the senator from Kennebec, Senator Hickman, will be excused from roll call votes. Have all now voted? The Secretary will close the vote. The Chair will announce the total. 20 senators having voted in the affirmative and 14 in the negative. The majority ought to pass as amended. Report prevails. First reading of the printed bill.
Emergency preamble. Whereas
Chair
action
understands
resolves the
Senator from
legislature.
Cumberland, Senator Talbot Ross moves the reading to be dispensed with. The Secretary will read Committee Amendment A.
Committee Amendment A to House
Chair
Paper
understands Senator from
1421.
Penobscot, Senator Hagan moves the reading of Committee Amendment A be dispensed with. Is it now the pleasure of the Senate to adopt Committee Amendment A? It's a vote. Now the pleasure of the Senate that the rules be suspended to give this bill its second reading at this time by title only. It's a vote.
An act to prohibit the disclosure of non-public records without proper judicial review.
Is it the pleasure of the Senate that this bill be passed and gross as amended in concurrence? It's a vote. Was there any objection to all matters thus acted upon being sent forthwith? Hearing none, so ordered. Would leadership please approach? Okay. The Senate will be in order. Chair would announce that we are going to take up supplement number 3, supplement number 9, and supplement number 11. The chair calls your attention to supplement number 3, supplement number 3.
On supplement number 3, the Committee on Engrossed Bills report is truly and strictly engrossed the following bond issue. Item 7-1, an act to authorize the general fund bond issues to support Maine's agricultural and forestry sectors.
Chair recognizes Senator from Cumberland, Senator Peirce.
Thank you, Madam President. I move this to be tabled until later in today's session.
Senator from Cumberland, Senator Peirce moves that this item be tabled until later in today's session. The chair draws your attention, apologies, 7-2.
Committee on Engrossed Bills report is truly and strictly engrossed the following acts on supplement 3. Item 7-2, an act to establish an excise tax on cannabis pre-roll.
Would the secretary please defer, and the chair would recognize the senator from Rustic, Senator Stewart.
Still need to deal with the previous motion, which was to table item 7-1. There was not
Thank
a
you.
hammer vote, so just
Is this the pleasure of the Senate that this item be tabled until later in today's session? Let's vote. Chair now recognizes the senator from, the chair recognizes the secretary before she recognizes the senator from Androscoggin.
Committee on Engrossed Bills report is truly and strictly engrossed the following acts. Item 7-2, an act to establish an excise tax on cannabis pre-roll and to change the tax on potentially intoxicating hemp products. Item 7-3, an act to prohibit the unauthorized use of drones on or over the premises of correctional facilities and jails. Item 7-4, an act relating to non-compete agreements between employers and healthcare practitioners.
The chair now recognizes the senator from Androscoggin, Senator Rotundo.
Request that we set aside item 7-2.
Senator from Androscoggin, Senator Rotundo moves that we set aside 7-2. It will be set aside. In regards to item 7-3 through 7-4, these bills having had their 2 several readings in the House, their 2 several readings in the Senate, have been passed, being engrossed, and reported by the Committee on Engrossed Bills as truly and strictly engrossed, have been passed to be enacted in the House and signed by the Speaker. Is it the pleasure of the Senate that these bills must be passed? These bills are passed to be enacted. These bills are passed to be enacted and will be signed by the President and presented by the Secretary to the Governor for approval. The chair now recognizes the senator from Androscoggin, Senator Rotundo, in regards to 7-2.
President, I move that item 7-2 be placed on the special appropriations table.
The senator from Androscoggin, Senator Rotundo, moves that item 7-2 be set on the special appropriations table. Is this the pleasure of the Senate? It's a vote. Chair lays before the Senate supplement number 9. Supplement number 9.
Supplement number 9, item
Chair understands Senator from
5-1
Knox, Senator Beebe, Senator moves the reading of item 5-1 be dispensed with and report be accepted in concurrence. Is this the pleasure of the Senate to vote? First reading of the printed bill.
Enacted by the
Chair
people of the state
understands
of
Senator
Maine
from
as
Waldo,
follows.
Senator Curry moves the reading be dispensed with. The Secretary will read Committee Amendment A.
Committee Amendment A.
Chair
to House
understands
District
Senator from Kennebec,
313.
Senator Searway moves the reading of Committee Amendment A be dispensed with. Is it now the pleasure of the Senate to adopt Committee Amendment A? It's a vote. Is it now the pleasure of the Senate that the rules be suspended to give this bill its second reading at this time by title only? It's a vote.
An act regarding the Department of Public Safety.
Is it the pleasure of the Senate that this bill be passed and engrossed as amended in concurrence? It's a vote. The Chair lays before the Senate supplement number 11. Supplement number 11.
On supplement number 11, the Committee on Engrossed Bills report is truly and strictly engrossed following acts. Item 7-1, an act to make biofuel commercial production and commercial use tax credit in the renewable chemicals tax credit refundable. Item 7-2, an act to safeguard personal information and strengthen tenant rights in Maine.
The Chair recognizes the Senator from Androscoggin, Senator Rotundo.
Request that we set aside item 7-1.
The Senator from Androscoggin, Senator Rotundo, moves that we set aside 7-1. It'll be set aside. In regards to item 7-2, this bill having had its two several readings in the House, its two several readings in the Senate, been passed to be engrossed and reported by the Committee on Engrossed Bills as truly and strictly engrossed, been passed to be enacted in the House and signed by the Speaker. Is it the pleasure of the Senate that these bills be passed to be enacted? These bills are passed to be enacted and will be signed by the President and presented by the Secretary to the Governor for approval. The Chair now recognizes the Senator from Androscoggin in regards to 7-1.
Item be placed on the special appropriations table.
The Senator from Androscoggin, Senator Rotundo, moves that this item be placed on the special appropriations table. Is this the pleasure of the Senate? It's a vote. The Chair would now direct members' attention to unfinished 5. Unfinished 5. House reports from the Committee on Labor on a bill, an act to amend the requirements governing self-insurance plans in the Paid Family Medical Leave Benefits Program, tabled April 6, 2026 by Senator Stewart of Aroostook, pending motion by Senator Tipping of Penobscot to accept the majority ought to pass as amended by Committee Amendment A, report in concurrence. A roll call has been ordered. The pending question before the Senate is acceptance of the majority ought to pass as amended report. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? The Chair recognizes Senator from Kennebec, Senator Bradstreet.
Thank you, Madam President. Madam President and members of the Senate, I am standing here now asking you to really consider what the LD 2018 majority report really does. Briefly, its ultimate effect would be to unnecessarily drive up costs for employers, and I might add employees also, since they participate in the funding of the Paid Family Medical Leave Program. What it does is prevent the common sense efforts of businesses that wish to pool resources to get better deals on surety bonds that will help their ability to pay employee benefits. Remember, private self-insured plans are allowed under the PFML law. This was one of the big selling points when the law was being promoted. Under such plans, there are only two requirements. Number one, employers must provide their employees with benefits that are substantially equivalent to the state plan. And number two, employers must maintain a surety bond that guarantees payment to those benefits, Pooling of resources to better obtain pricing on these bonds in no way endangers the payment of benefits to employees. Rather, the majority report restricts self-insured employers from maximizing the financial and administrative tools available to them, such as procuring quantity discounts on surety bonds or sharing risks. I hope we all realize that by lowering costs just to run the program, not in any way cutting back employee benefits, is of value to both the employer and employee in providing savings that can be utilized for other employee benefits. It's certainly good for many employees who themselves pay for the program that it may be run as efficiently and cost-effectively as possible. The majority report actually shows tacit agreement that pooling of resources can save money by allowing pooling to save on administrative costs. Why wouldn't that also be true with surety bonds? To say otherwise does not make any sense at all. The Department of Labor seems to be concerned about the state plan's viability if pooling of surety bonds is allowed. But please note this, the state fund has more than 53,000 businesses, not individuals but businesses that pay into it. Yet there are right now about 50 that participate in the group pooling, 50 out of 53,000. Moreover, the Department of Labor December 2025 actuarial report does not indicate any solvency risk, and indeed the report projects a current surplus of $209 million, which will increase to more than $429 million by 2035. If by some chance the fund starts to have a surplus decrease, it will come about very gradually, and there will be ample time to make any corrections. Another issue with the majority report is its retroactivity provision. This matter is now pending in a Superior Court case. After initially gaining approval for self-insured plans with pooled surety bonds, as part of them, the DOL soon after sent out letters asserting that the law forbids it. Ladies and gentlemen, there is no place in the statute that forbids the pooling of surety bonds. The DOL is on shaky legal grounds. It knows this, and their remedy is proposing a retroactive law that is certainly contrary to common practice and precedent. How would any of us like it if we were to be fully compliant with any law and months later but find that the relevant law is being changed so we are now in violation? Regardless of how you may feel about the rest of the bill, this should be a concern to all of us. Conversely to the majority report, the minority report takes a balanced, practical approach. It maintains strong employee protections. Employers remain strictly liable for paying all employee benefits. It provides through flexibility in allowing self-insured employers to realize financial and administrative cost savings by managing their programs more efficiently and economically. It provides clarity and consistency by upholding clear and predictable standards for compliance. And it supports workers by realizing the less of their money they'll go into administrative and higher-priced financial requirements, and so can instead be available for higher wages, bonuses, and other benefits. Members of the Senate, I believe that each one of us in our daily lives would certainly choose to save money, some of our own money, if we can find ways to realize it. This in no ways diminish or jeopardize the quality of what we receive for that money. It's only common sense that we do this if we can. Is this not also true for businesses and workers? The majority report very definitely prevents this from happening under the Paid Family Medical Leave Program. We shouldn't allow that. I hope that we can all vote against the pending motion and then adopt the minority report. Thank you very much, Madam President.
The chair recognizes the senator from Penobscot, Senator Tipping.
Thank you, Madam President. The Paid Family Medical Leave Program is incredibly important. It finally allows all Mainers to take time off work and keep their job and have some income when they're needing to care for a new child or care for themselves or a family member when they're injured or sick. This bill is pretty straightforward. It's meant to clarify that law, prevent its significant weakening by allowing completely unregulated group trust insurance schemes, something that was never intended and that would undermine coverage and increase costs for all other businesses and hundreds of thousands of Mainers. The bipartisan majority report on this bill is a compromise that allows the pooling of funds for administration, but not the undermining of the program and the allowing of the dangerous pooling of risk in unregulated trusts. Thank you, Madam President.
The pending question before the Senate is acceptance of the majority ought to pass as amended report. If you're in favor, you'll be voting. The chair recognizes the senator from Androscoggin, Senator Bickford.
Madam President, I'd like to pose a question through the chair.
The member may proceed.
Okay. So, like businesses, for example, banks or grocery stores, if they wanted to get together and purchase a family medical leave policy as a group insurance rather than go through the state, why are we against that? The second question is, how in the world does that increase costs for others if they're not even on the state plan? Please.
The senator from Androscoggin, Senator Bickford, has posed a question to
Thank you, Madam President. And my colleague and cousin, Senator Bickford, asked a couple of good questions. To be clear on that, we do allow that. It's called an insurance plan.
Oh,
You know,
okay.
you're allowed to have an insurance plan that other, people buy into. Pool risk, you're just not allowed to do it with an unregulated trust. And the second question, remind me of?
How does it increase cost?
Has
to
increased.
others?
One of the problems with these trusts is that potentially they could kick out members that actually use the product because they're not regulated in that way. That would basically be socializing the risk in these situations, privatizing the gain. It would be putting that back onto the state plan, which the rest of us are paying for, making us all pay a little bit more so that they get a better deal in an unregulated way, which I don't think is fair, and I obviously don't think is the intent of the law or what we previously voted for. Thank you.
Chair recognizes Senator from Kennebec, Senator Bradstreet.
Thank you, Madam Chair. I would challenge that they're unregulated, and costs, anybody can drop out of that plan anytime they want to. It's voluntary. And to think that this is jeopardizing the entire plan, 50 businesses out of 53,000, that's kind of hard to believe. Thank you.
The pending question before the Senate is acceptance of the majority ought to pass as amended report. If you're in favor, you'll be voting yes. If you're opposed, you'll be voting no. Is the Senate ready for the question? Sergeant at Arms will secure the chamber. The Secretary will open the vote. Chair would note that the Senator from Kennebec, Senator Hickman, will excuse from roll call votes. Chair would note the Senator from Oxford, Senator Bennett, will be excused from roll call votes. Have all now voted? Have all now voted? The Secretary will close the vote. The Chair will announce the total. 19 senators having voted in the affirmative and 15 senators having voted in the negative. The majority ought to pass as amended report prevails. First reading the printed bill.
Being enacted by the people,
Chair
State of Maine
understands
as
Senator
follows.
from York, Senator Rafferty moves the reading be dispensed with. The Secretary will read Committee Amendment A.
Committee Amendment
Chair
A,
understands
House
Senator from
Paper
Kennebec, Senator
1348.
Bradstreet moves the reading Committee Amendment A be dispensed with. It's now the pleasure of the Senate to adopt Committee Amendment A. It's a vote. It's now the pleasure of the Senate. Let the rules be suspended to give this bill its second reading at this time by title only. It's a vote.
An act to amend the requirements governing self-insurance plans and paid family and medical leave benefits program.
Is it the pleasure of the Senate that this bill be passed and engrossed as amended in concurrence? It's a vote. Is there any objection to all matters thus acted upon being sent forthwith? Hearing none, so ordered. The Chair would note at this time we have a few items we have not caucused. We will break briefly. My intention is 15 minutes to half an hour. Listen for the bell. That the Chair recognizes Senator from Rustic, Senator Stewart.
Republicans are going to caucus in the third floor office immediately, so just grab your supplements. I think there's only one that we haven't caucused on our end, so supplement 12. So snag that, and we will meet in just a couple minutes. So.
Chair recognizes Senator from Cumberland, Senator Peirce.
Thank you, Madam President. The Senate Democrats will caucus in 3:20. We have food.
The Senate will stand at ease until the ring of the bell.
you.